A recent judgment of the Court of Justice emphasises and illustrates the principle of direct effect as it applies to VAT law. VAT law throughout the EU is set down by Council directives. A Council directive is EU law, but it's not in itself national law in any member state. Member states are required to amend their own domestic law to implement the directive. Each directive contains a date by which member states are required to comply with it. For example, the Principal VAT Directive contains an implementation date of the 1st of January 2008. The 2008 Refund Directive had to be implemented in national law by the 1st of January 2010. By contrast, a regulation is deemed to be incorporated in national law already. It's therefore binding on all the member states on the date on which it takes effect. The implementing regulation of 2011 took effect throughout the EU on the 1st of July 2011, without any action by member states' legislatures. Problems often arise because national legislation is not exactly the same as the directive, for all sorts of reasons. Some are to do with translation, some are to do with historical differences in the way in which laws are drafted or worded in different countries. Some are because countries have tried to expand on or redefine the terms of the directive, not always with the intention of changing it, but possibly to make it clearer what it means in the particular circumstances of that country. Where there's a possible difference between the meaning of a national law and the underlying directive, the national courts are required to apply what is known as the principle of conforming construction. This was established in a Court of Justice judgment on a company called Marleasing, so it's often referred to as the Marleasing principle. If the national court finds that the national legislation is capable of different interpretations, the national court is required to follow an interpretation which is consistent with the directive rather than one which is not consistent. That means it's not necessary to go to the Court of Justice for enforcement of the EU law. The national courts are required to apply it in interpreting their own laws. If the national court decides that the national law can't be interpreted as complying with the directive, there are a number of possible solutions or consequences. One is that the member state may in due course change its rules, and if it doesn't, the EU Commission may take infringement proceedings in the Court of Justice to obtain an order requiring a change of the rules. But that's for the future. The discrepancy between the national law and the directive may have been highlighted in a current dispute, so that needs to be resolved for a trader who may suffer the effect of a non-conforming law. The European treaties oblige member states to give direct effect to directives in their national courts. This means that in certain circumstances, which I'll come back to in a moment, the national law is set aside and the directive takes precedence. Again, it's not necessary to go to the Court of Justice to enforce this. The national court itself must apply the directive instead of the national law. If the directive is clear in its meaning, it's mandatory, that is, it doesn't allow any differences in treatment to member states, and the directive is applicable to the specific facts. If the national court is not sure what the directive means, or not sure whether the national law complies, or not sure how it applies to the particular facts, then the national court will refer questions to the Court of Justice to determine the matter. The Court of Justice's answer will set out the principles which the national court should then apply in coming to a final decision on the case. In some cases, it's clear who's won as soon as the Court of Justice gives the answer, but in others, it'll still be a difficult exercise for the referring court to think through the consequences of the judgment and the application of the principles. All that brings us to the recent decision in GMAC, case C589 of 12. One of the crucial principles of direct effect is that in a dispute between an individual or a legal person, such as a company, and a part of the state, such as the tax authorities, the individual or the company can rely on the directive as taking precedence over the national law. This is called vertical direct effect, but it only works one way. The state can only rely on its own national law, and the state must implement the directive properly if it's to get the benefit of a different treatment within it. So a trader can rely on the directive to get a benefit in relation to past transactions, but the member state will have to change its own laws in order to get the benefit of the directive in relation to future transactions. The GMAC case is about the implementation of what is now Article 90 of the Principal VAT Directive in the UK. This provides that in the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount shall be reduced accordingly under conditions which shall be determined by the member states. So where a trader has accounted for output tax on a supply, but then doesn't get paid the full amount that the output tax was calculated on, the trader can get some VAT back. The precise details of how that works will be part of the implementation in the national law of each member state. Strangely, Article 90 then states that, in the case of total or partial non-payment, member states may derogate from this rule. That is, it's not mandatory to give relief for non-payment. It is mandatory to give relief for cancellation or refusal of a supply, or for a price reduction after the supply takes place. Well, the UK had not derogated from the rule. The UK allowed what was called bad debt relief, which covered the situation where a trader had made a supply and hadn't been paid all of the consideration. However, the UK imposed various conditions on claiming the relief. Up to 1990, a trader could only claim if the debtor could be shown to be insolvent, and up to 1997, a supplier of goods could only claim the relief if legal title to the goods had passed to the customer, who then didn't pay. Note that the UK could have derogated from the provision by not having a bad debt relief at all, but after deciding to have a relief, the UK couldn't impose conditions which weren't in the directive. At an earlier stage of the case in the UK courts, the judges had decided that these extra conditions were not in accordance with the EU law, so applying direct effect, the trader had a good case for getting a relief that the UK law would deny. The problem was particularly acute for a company like GMAC, which sold goods on hire purchase. Legal title on a hire purchase sale passes only with the final instalment of the money. So if you don't get paid all the money, legal title never passes, and according to the UK law, you could never claim bad debt relief. The UK courts were satisfied that the company had directly effective EU rights in this circumstance. However, there was an alternative relief which the UK law allowed to hire purchase dealers. The UK law allowed them to treat the sale of any repossessed goods as outside the scope of VAT. So they couldn't claim back any of the VAT they'd already accounted for the first time they sold the item, but if they managed to recover the item and sell it again, at least they wouldn't have to account for any more output tax. Depending on the figures, that could be better or worse than claiming bad debt relief. Obviously, if the goods couldn't be recovered, or were in such bad condition that they couldn't be resold, the UK's relief wouldn't be of any benefit at all. Naturally, GMAC had claimed this UK relief throughout the period in dispute, because it was what the UK law offered. It was only much later that they decided to claim that they should have had bad debt relief under the directive as well. Because the government can't rely on direct effect, the result could be that the company would end up with both benefits: bad debt relief under the directive, and not taxing the second sale under the UK law. The UK tax authorities argued that this would give them a windfall that wasn't intended by any of the laws and couldn't be the right answer. The UK courts were not sure whether this might possibly be a valid reason to refuse a repayment of the bad debt relief, so questions were referred to the Court of Justice. The court gave this argument very little credit. The problem had been created by the UK law on both sides. It had failed to implement a directive properly, which it had to do, and had then introduced a completely different relief, which was probably not allowed by the directive. Those two wrongs couldn't be combined somehow to make any sort of a right. The trader was entitled to the bad debt relief under the directive, and the existence of a totally different relief, which would not be equivalent in value anyway, couldn't be relevant in deciding whether they should enjoy their directive rights. The UK has now changed the law, so a trader can't get both reliefs on the same transaction. And there is still a further argument that GMAC claimed the relief after a cut-off date, and therefore shouldn't get back this overpaid VAT from years and years ago. But the principle of direct effect says that their claim is valid, even if it then fails on administrative grounds.